Hello, everyone. Thank you for joining us today for this installment of Business Break. Today, we're going to be talking about hiring employees and how to ensure that you as the employer start the relationship off right from the offset. In our presentation today, we're going to be looking at the various stages of hiring an employee, including how to advertise for a position, conducting the interview, setting the conditions of employment, and drafting employment agreements and policies. When you are advertising for an employment position, most employers start the process off with an ad. This is a completely normal practice and something that you may want to do to hire an employee, but you do need to make sure that your ad meets certain requirements. The first being that ads cannot discriminate based upon certain distinguishable characteristics as set out in the Human Rights Act. There can be some elements of your ad that may indicate that there's a discriminatory element only if it's absolutely necessary for the performance of the job. So for example, if you are advertising for a bus driving position, a bus driver needs to be able to see in order to drive that bus. So that can be a requirement, is that the person could not be blind in order to qualify for that position. Your ad should also clearly set out the job description, qualifications, the compensation, what the start date and term of the employment might be, the location in which the employee would be working, and any conditions of employment. For instance, are you going to require that a criminal record check be completed?
So the other thing that comes along with ads is usually then once somebody applies for a job through an ad or other means, then there'll be an interview. So with interviews, some of those similar considerations apply. So one of the main things is that your interview questions cannot be discriminatory in any way. And so one that we often see and that we often strongly recommend not be asked is whether a prospective employee is planning on having children. This is discriminatory often on the basis of gender. And so that's something to stay away from. The other thing that can be helpful in interviews is to ensure that you have an established set of questions, but with some flexibility so that you ensure that the hiring process is fair to everyone. At the end of the day, when you're going through those kind of initial stages of hiring an employee, you want to make sure that there's a lot of fairness in the process to make sure that you're not falling into any of those kind of discriminatory practices. The other thing that can be quite helpful in an interview is to ensure that you're using it to expand on what the applicant has indicated are their qualifications, so that you also ensure that you're getting the most qualified employee for the job.
It is possible for an employer to make a conditional offer of employment, meaning that you are indicating that you will hire the employee subject to certain conditions being met. However, those conditions that are placed on employment need to be necessary for the performance of the job or have some link to the performance of the job. So some examples are that you might want to hire an employee conditional on them obtaining a criminal record check or a vulnerable sector check. Another example of this that I'm familiar with is that if you were hiring a temporary foreign worker, your offer of employment may be conditional on the employer obtaining a labor market impact assessment and the worker obtaining a valid work permit. So
once you've gone through that process and you found an employee that meets all of your qualifications and they've passed any of those conditions of employment, the next step is then to formalize that and put something in writing. Having a written employment agreement isn't legally necessary, but it's very, very strongly recommended. Oral agreements are possible in the context of an employment relationship, but can lead to some pretty sticky situations because there's a lack of clarity in terms of the terms relating to that relationship. So we always recommend that an employment agreement be in writing. there can be a variety of complexity when it comes to an employment agreement, and that depends largely on the type of employee. So if you're dealing with just sort of a basic employee, they have just a set of job duties, they're paid for those job duties, you know, and they work kind of a regular schedule, that can be a pretty standard agreement. But if you're dealing with somebody that's in an executive or managerial or kind of supervisory role, sometimes then the agreement can become a little bit more complex because there are just different considerations that apply to somebody that's coming to a job with more expertise, knowledge, maybe there for longer, things like that. Some of the standard terms that we often recommend including in employment agreements, some of them are obvious, but things like how long is the agreement? Is it for a fixed term, so for a year, or is it for an indefinite term? Compensation, hours of work, that can include things like overtime as well. Job duties, whether they're receiving benefits and what those benefits are. Vacation, and vacation can also include some other terms that, so things like, does vacation accrue over the year? Do you have a set amount of time? How much can I transfer into the next year? Things like that. We now recommend including a temporary layoff provision in all employment agreements. Termination provisions are very important, so it's very clear to employees what will happen if either they terminate the agreement or if the employer terminates the agreement. And then for a lot of employers, confidentiality obligations are also generally quite important. The other important point to make about employment agreements is that you can't include anything in an employment agreement that would be less than what an employee is entitled to under the Employment Standards Code. You can give them way more, but you can't do anything less than. So essentially you can't contract out of legislation that applies to employees. So then the other thing that's kind of an associated part of an employment agreement is any employment policies that an employer has in place. It's really good practice to have your employment policies incorporated into your employment agreement. That can be as easy as a provision in the employment agreement that says, see Schedule A, which includes the policies of the employer, or something to that effect. Employees have to understand and agree to all policies for them to be enforceable. Again, if it's in their employment agreement, they're signing off on it, they'll have read the policies before being kind of put into their role, and that's enough. And then the other piece, again, if it's incorporated into the agreement, this is easy, but new employees should be given copies of all employment policies, because the last thing you want is a situation where you're disciplining an employee under a policy and they've never seen it, they don't know what it is, because in that situation, then it's pretty unlikely that you'll be able to enforce that policy. So those are sort of I guess the initial steps once you have that employee in place, is to make sure that agreement and any associated policies are incorporated and provided to them so that they understand and agree to them.
Thanks for joining us for this segment of Business Break. As always, if you have any questions or need advice specific to your situation, do not hesitate to give Lauren or I a call.